Hello, everyone. Before we begin, I want to acknowledge the land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous peoples from across Turtle Island, and we are grateful for the opportunity to work on this land. I'm delighted to have this opportunity to warmly welcome everyone to what is a true highlight of our academic year, our Grand Moot. It's definitely one of the perks of the new role that I've assumed to get to kick off this wonderful event. I don't want to take up a lot of your time. We all want to enjoy the main attraction, and I, for one, actually can't wait to hear the arguments around this year's very topical set of issues. But I did want to take a moment to highlight how hard, first of all, the mooters, Teodora, Pasca, Olivia, Geri, Angelova, and Hana, Awwad, have worked to prepare for today, and I know that we're in for a real treat. I also want to recognize McCarthy Tetro, both in terms of funding this event and in terms of a lot of time devoted to it. I want to briefly acknowledge Bill Black and his colleagues at McCarthy Tetro, but I also want to mention Megan Bridges and Liliana Stanic, not just because they are former Grand Mooters, but because they've also put an enormous amount of work into preparing for our event today. And last not least, two people deserve super special thanks, the two people who've worked the hardest to make this event happen, and that's our two co-chief justices, Saambavi Mano and Alina Yu. They did a lot of heavy lifting, all the heavy lifting in writing the problem, organizing the event, and they've worked miracles in setting up this special event to take place remotely. So let me turn the proceedings over to our wonderful co-chief justices. Over to you.
Okay, thank you, Dean Brunnee, and good evening, everyone. My name is Saambavi Mano, and Alina Yu and I are the student chief justices of this Grand Moot. We would just like to begin by echoing Dean Brunnee's thanks to our sponsor, McCarthy Tetro, for their continued support of the Grand Moot. We really wouldn't be able to put on this event every year without their generous support, so a huge thank you to McCarthy. Alina and I are here to give a brief overview of the issues that you're going to see argued before you tonight. This appeal is taking place in the fictional country of Flavel, which is functionally identical to Canada with respect to its constitution, parliamentary system, judicial system, and social and political history.
This appeal challenges the constitutionality of the Vaccination Act, or the VA. The VA was passed by the government of Flavel in August 2020 in response to a global human infectious respiratory syndrome, or HIRS pandemic. HIRS is a highly contagious infectious disease that carries a risk of serious complications. It was first identified in 2019 in several highly populated countries around the world, including Flavel. In early 2020, the World Health Organization declared that the HIRS outbreak was a global pandemic. The pandemic has resulted in over 20 million known HIRS cases and 800,000 deaths. About 90% of people who are exposed to HIRS and who are not immune to the disease will contract HIRS. People who contract HIRS are infectious to others within a few days of infection. Since the early contagious period is often asymptomatic, people may transmit the virus without showing any signs of illness. Children can carry high viral loads despite showing no symptoms. The long-term consequences of the virus are unknown.
A HIRS vaccine was successfully developed in August 2020. The vaccine has a median vaccine efficacy rate of 73%, whereby 73% of vaccinated people who subsequently contract HIRS will not actually contract the virus. Sorry, who subsequently are exposed to HIRS will not contract the virus. 73% is an unusually low vaccine efficacy rate, which will require near universal coverage in order to achieve herd immunity. Practically speaking, this means that almost 100% of Flavelians will need to get vaccinated to stop the spread of HIRS. Following the successful development of the HIRS vaccine, the government of Flavel decided to mandate HIRS vaccinations through the Vaccination Act. Section 3 of the Vaccination Act requires all persons above the age of 4 to receive the HERES vaccine. Section 4 of the Vaccination Act provides an exemption for those with valid statements of medical exemption. Section 4 also requires persons with medical exemptions to undergo HERES testing at least once every 14 days and to self-isolate if they cannot obtain a negative HERES test in that time period. Persons above the age of 12 who fail to comply with Section 3 or Section 4 of the VA are guilty of an offense and are liable to escalating penalties. These penalties include a range of fines from $1,000 to $20,000 and a potential term of imprisonment of not more than 14 days. However, at the time of this appeal, the government of Flavel has not pursued imprisonment as a penalty for violations of the VA.
In November 2020, the appellant, Mr. Lucas Yuno, was charged and fined $1,000 under Section 3 of the VA after failing to produce a vaccination card at a grocery store. Mr. Yuno is a holistic healthcare practitioner and a registered member of Flavelians for Vaccine Choice, a not-for-profit advocacy group with the goal of ensuring that Flavelian families are making fully informed and voluntary decisions about vaccination. Mr. Yuno avoids all non-natural medical treatments and has not received vaccinations for nearly 40 years. His rejection of vaccination stems from his experience with the Montpella vaccine. During one of Mr. Yuno's work trips abroad, the host nation experienced an outbreak of a rare local disease called Montpella. To limit the spread of the disease, all healthcare workers, including Mr. Yuno, were asked to receive the Montpella vaccine. The vaccine did not have a 100% efficacy rate, and despite being vaccinated, Mr. Yuno suffered a full bout of Montpella.
Since his Montpella diagnosis, Mr. Yuno has suffered from anxiety, panic attacks, and sleeplessness. He maintains that his symptoms are not rooted in his diagnosis, but rather in his involuntary and uninformed decision to receive the Montpella vaccine. He maintains that he lacked the necessary information about the Montpella vaccine efficacy rate and the potential symptoms of vaccination. Mr. Yuno has been prescribed medication to help manage his psychological symptoms, but he does not have an official diagnosis of disorder. Mr. Yuno also has not sought a medical exemption under Section 4 of the VA because his symptoms do not rise to the level of a DSM-5 mental disorder, and because he believes the exemption does not accurately reflect his motivations for rejecting vaccination. Mr. Yuno maintains that he understands why the HERES vaccine is recommended, and he appreciates the consequences of failing to receive the vaccination. However, he does not trust the vaccine and believes that a 73% efficacy rate is not high enough to justify intruding upon his medical choices.
Mr. Yuno has challenged Section 3 of the VA on the basis that it unjustifiably infringes Section 7 of the Flavelian Charter of Rights and Freedoms. Mr. Yuno alleges that Section 3 of the VA deprives him of his liberty and security of the person in a manner that is not in accordance with the principles of fundamental justice. He further argues that this infringement cannot be justified under Section 1 of the Charter despite the pandemic context. The respondent in this appeal is the Attorney General of Flavel. The Attorney General argues that the VA accords with the principles of fundamental justice, and in the alternative, that it is a reasonable and justifiable limit in a free and democratic society. At trial, both Mr. Yuno and the Attorney General of Flavel led expert evidence on the effectiveness of vaccinations for infectious disease control. The experts whose evidence was accepted at trial arrived at the following key findings. First, not every person needs to be vaccinated to prevent vaccine-preventable disease outbreaks. 99% of possible infections can be prevented without 100% vaccination coverage. However, since the HERS vaccine has an unusually low vaccine efficacy rate of 73%, Flavel will require near universal coverage to achieve herd immunity. Second, research on vaccination coverage for other diseases in Flavel shows that coverage rises in jurisdictions that implement mandatory vaccination schemes. However, the ultimate coverage rates for mandatory vaccination jurisdictions are not markedly different from coverage rates for voluntary vaccination jurisdictions. Third, mandatory vaccination jurisdictions have higher rates of medical exemptions than voluntary vaccination jurisdictions. Mandatory vaccination jurisdictions also see an immediate rise in the rates of medical exemptions once personal belief exemptions are eliminated. However, in general, vaccination coverage also rises in jurisdictions that eliminate personal belief exemptions.
The fourth finding was that about 5% of the Flavelian population would be unable to get vaccinated against HERES for medical reasons. In addition, surveys show that 2% of Flavelians would refuse to get the HERES vaccine, 68% would be willing to get the vaccine, and 30% declined to answer. The respondents' expert notes that the HERES pandemic has coincided with a period of increased vaccine hesitancy, both in Flavel and worldwide. And finally, vaccination rates for other vaccine preventable diseases are lowest among persons in the lowest socioeconomic quintile in Flavel. Vaccination rates are particularly low among migrants and individuals with high housing insecurity. The appellant's expert indicates that logistical and financial considerations, such as difficulty securing transport and the inability to take time off work, might explain lower vaccination rates in these communities. Mr. Yuno's challenge was first heard at the Superior Court of Falconer before Justice Abrakovich. At trial, Justice Abrakovich found that Section 3 of the Vaccination Act infringes Section 7 of the Charter. She found that the mandatory vaccination scheme and its associated penalties engage the Section 7 liberty and security interests in a manner that is overbroad, and thus contrary to the principles of fundamental justice. Justice Abrakovich also found that the Section 7 infringement could not be justified under Section 1. Key to her Section 1 finding was her characterization of the legislative objective as achieving herd immunity by ensuring sufficient vaccination coverage in Flavel. She found that the legislation is not minimally impairing and that the deleterious effects on Section 7 rights far outweighed the salutary effects of a mandatory scheme.
The Attorney General of Flavel appealed the decision to the Falconer Court of Appeal, where it was heard by a 3-judge panel. The majority of the court found that there was not Section 7 infringement, while the dissent maintained that the Act infringed Section 7 in a manner that cannot be justified under Section 1. Justice Coutinho, writing for the majority, found that there was no infringement of Section 7 because the Act's deprivation of liberty and security was in accordance with the principles of fundamental justice. Justice Coutinho also disagreed with Justice Abrakovich's formulation of the objective of the provision. She found that the objective was to achieve herd immunity as soon as possible by ensuring maximum vaccination coverage. On this formulation of the objective, she found that any Section 7 infringement would be justified under Section 1. Justice Bolyevich, dissenting, agreed largely with the lower court decision. At the final stage of the Oakes test, she added that the mandatory vaccination scheme is somewhat counterintuitive, since it contemplates the imprisonment of unvaccinated people in the middle of a global pandemic. She found this aspect of the scheme to be inconsistent with the goal of achieving herd immunity.
Following the decision of the Falconer Court of Appeal, Mr. Yuno appealed the decision to this court, the Supreme Court of Flavel. We will now cede the floor to our judges and our 4 mooters, Teodora Pasca, Olivia Ng, Geri Angelova, and Hana Awwad.
The Supreme Court of Flavel is now presiding.
Good afternoon, everyone. We are here to hear the case of Yuna and Flavel Attorney General. I'd ask counsel to please introduce yourself and begin.
Thank you, Chief Justice Martin. My name is Teodora Pasca, and my co-counsel is Olivia Ng, and we represent the appellant, Mr. Lucas Yuno. And my colleagues are Geri Angelova and Hana Awwad, and they represent the government of Flavel.
Please begin.
The right to make your own medical choices is vital in a free and democratic society. That right does not lose its significance in the context of a pandemic. The government of Flavel, in passing the Vaccination Act, has made it an offense to be unvaccinated, essentially regulating refusing to take a medical treatment. The punishments for that offense range from a mandatory minimum fine of $1,000 to potential jail time upon repeated noncompliance. These penalties can be issued indefinitely until a person changes their mind. The act infringes people's liberty and security of the person in a manner so significant that it cannot be justified even during a pandemic. The act violates Section 7 of the Charter and cannot be justified under Section 1. I will be dealing with the Section 7 submissions today. On behalf of the appellant, I will first argue that the act is overbroad, then that the fines are grossly disproportionate, and finally that jail is a grossly disproportionate and arbitrary penalty for this offense. Then my co-counsel, Ms. Ng, will turn to the Section 1 submissions, explaining why this violation is not justified. My submissions on the principles of fundamental justice begin at paragraph 30 of the appellant factum. Before getting into those submissions, it's important to identify the objective that we're working with for the purpose of the Section 7 analysis. Here we have two objectives at play. The general objective of the Act is found under Section 2, which is to protect the health and well-being of people in Flavel against HERS. The specific objective of Section 3 was identified on the charter application by Justice Abrakovich, which is to ensure sufficient vaccination coverage in order to achieve herd immunity. The Act is overbroad in relation to both of these objectives. With respect to the specific objective under Section 3, achieving herd immunity is not a numerical cutoff.
May I ask this question? Does it matter if the objective is framed as herd immunity or herd immunity as soon as possible?
From the appellant's perspective, framing the objective to include as soon as possible is inappropriate. As the Supreme Court held in Moriarty, doing so may conflate the means used to achieve the objective with the actual ends at stake. As soon as possible, in our view, goes towards the effectiveness of a measure and is not a general purpose in and of itself. That said, my co-counsel in her Section 1 submissions will address why both of our proposed alternatives to the government scheme achieve the objective on effectively the same timeline. And so timeliness does not make a difference here. The Act is overbroad in relation to the objective of herd immunity because it was not necessary to vaccinate people like Mr. Yuno, who have sincere and strong opposition against vaccination, in order to achieve the objective. Herd immunity should be understood as a sliding scale of protection. Certainly a high degree of protection is required in order to get us out of this pandemic, but the government has demonstrated that not everyone needs to be included in that mandate in order for the objective to be achieved. There is, yes.
Ms. Pasca, do we have any way of knowing the size of the group that may be in the similar position to Mr. Yuno? In other words, when it comes to medical exemptions, there is a relatively knowable group. And of course, the decision for small children is a knowable number. But isn't the amount of those who might be hesitant or have conscientious reasons to not be vaccinated an indeterminate group that could obviously undermine the goal of herd immunity?
In this case, we have expert evidence. Oh, pardon me.
Before you answer that, I'm just going to add one point to that, because it's a question I was thinking of, with the addition that how sincere does the person have to be? How do we know that he's sincere at all, and why would that matter? As long as you say that you don't want it, you could have serious conscientious reasons or frivolous reasons, I assume.
I will address Justice Sossin's question first. In this case, we have expert evidence from two different experts suggesting that people like Mr. Yuno, who are staunchly opposed to vaccination, represent 2% or less of the population. That's a relatively narrow margin, and it is certainly one that could have been accommodated from a charter perspective. It is unlikely to undermine the overall objective of the Act. Now, Justice Morgan, you're asking about how sincere a person's belief has to be. Certainly in the case of our client, Mr. Yuno has had panic attacks and experienced sleeplessness and anxiety as a result of a past experience. And the only reason why he isn't exempt from the act is because he does not qualify for a DSM medical exemption. And so in that context, this decision is very important to his life. And it is a serious intrusion on his bodily autonomy and dignity in order to force him to take this vaccine. My colleague will address one of our proposed alternatives in the Section 1 submissions, which is to carve out a non-medical exemption for people like Mr. Yuno, and she can explain more about how those determinations come to be made. The Act is also overbroad because it is arbitrary in some of its applications. This formulation of overbreadth was developed more recently in the jurisprudence in the Queen and Bedford and then in Moriarty. The Act, according to its fundamental purpose under Section 2, is really about risk. It's about risk of managing the spread of a contagious disease and ensuring we don't have sufficient outbreaks. But the Act manages risk arbitrarily in some cases. The vaccine is only 73% effective. Mr. Yuno can be taking significant precautions in his own life to prevent himself and others from getting sick. Yet a vaccinated person who has a false sense of security can potentially take no precautions and is not required to take any precautions according to the Act. And they do not face the significant penalties that Mr. Yuno does, despite posing the same or more of a risk to public health.
But can I stop you there in terms of the efficacy of this particular vaccine being particularly low at 73%? How do we fit that into the rational connection and the overbreadth when, if the vaccine itself has such a low efficiency rate, doesn't the government get to say that we need everybody to have it to mitigate the overall risk? Perhaps we could accommodate someone in Mr. Yuno's position were it an efficacy rate of 95%. So how do you deal with that on rational connection?
My co-counsel will discuss this further in her submissions, but essentially the low efficacy rate of the vaccine justifies some degree of coercion. But the government here has simply gone too far. If the vaccine were 100% effective, perhaps it could be an entirely voluntary scheme, and certainly that's ideal from a charter perspective. But fines and jail time were not at all necessary to enforce this mandate, and she can discuss that further in her submissions. From the perspective of Section 7, however, considering competing public policy interests and deferring to Parliament in achieving those interests is not relevant. Deference is not relevant to the Section 7 stage because there is a clear separation between Section 7's focus on the individual, as the court held in Bedford, and Section 1's consideration of the benefits to society at large. And so I will leave it to her to address the remainder of that concern. The principles of fundamental justice are designed to address laws that are inherently defective and could have been crafted in a way as to be more generous towards individual liberties without sacrificing the government's initial goal. That is exactly the problem with this act. And if there are no further questions on the overbreadth submissions, I'm prepared to move to the penalties because I think those illustrate the unique and severe impact on individuals that this act has. My submissions on the fine scheme begin at paragraph 35. Our position on the fines in the Act is that the government can use fines sometimes to achieve regulatory objectives and to deter non-compliance. But the manner in which it has chosen to do so in this case is not legitimate. It is grossly disproportionate, particularly for people who cannot afford to pay those fines. We take particular issue with the mandatory minimum fine of $1,000. Judges have no discretion whatsoever to refuse to impose that fine, even when they're faced with an individual who cannot be reasonably expected to pay it. In this case, we have expert evidence from Dr. Sugamar indicating that low vaccination rates are concentrated in low-income communities who may experience barriers like difficulty taking time off work or securing childcare and thereby be unable to get vaccinated in a timely manner.
Without, if I may, without putting, without painting it with too broad a brush, it may be that many offenses fall into that category. That is, people in a certain socioeconomic demographic may be statistically more, more targeted by any given criminal offense. Where does that get us, though, in analyzing a Section 7 problem? That could be that could apply to, half the criminal code.
It's certainly the case that all fines have the potential to be disproportionate towards low-income people. But the problem in this case is the mandatory fine. Usually judges have the ability to tailor a fine to an individual's circumstances. And in this context, any deterrent effect that the mandatory minimum had could have been achieved through merely the maximum end of the range. These fines range upwards of $20,000 for a single instance of non-compliance. There's simply no reason why a mandatory minimum fine is necessary. The Supreme Court has also acknowledged in Boudreaux, in the Section 12 context, for example, that a law's disproportionate impact on low-income people in a manner that sucks them back into the justice system, requires them to report constantly as to their income and their ability to pay, and is divorced from their moral blameworthiness, can violate the charter. And this is exactly what is happening here.
And Ms. Pasca, what's the significance in your submission of the discretion that does exist in between those ranges? So I understand your position on the minimum, but isn't there a range precisely to allow for that discretion and that important obligation on all public servants to only exercise statutory authority in accordance with the charter, and don't we need to take that into consideration as well?
The problem is that the low end of the range has been completely restricted. A $1,000 minimum fine is prohibitively expensive for somebody who doesn't have an income at all, or who lives on a $300 welfare payment, or who lives on the street and simply cannot afford to pay. Judges should be able to retain the full range of available fines in order to effectively sentence people for this offense.
Right, thank you.
But can we go back to, Boudreaux was a case that was decided under Section 12 of the Charter. And why is it that it has some persuasive impact here?
In the Queen and Nur, the Supreme Court held that issues of gross disproportionality when it comes to penalty can be addressed either under Section 12 or under Section 7. In this context, we chose to address it under Section 7 because there's something particularly offensive about this particular act, and that's the nature of repeated punishment. Somebody who remains unvaccinated faces fines and repeated convictions until they change their mind or somehow get themselves out of the difficult circumstances they are in. So somebody can be convicted of this offense despite not doing anything more to be morally blameworthy, potentially every 7 days, meaning that fines can accumulate rapidly into tens or even thousands of dollars. That's a situation that not only is limited to, that is not limited to just the individual punishments issued, but affects the course of an individual's life. And so Section 7 seems like the appropriate place to deal with that issue.
You say 7 days. Where do you get the 7 days from? And what about the argument that prosecutorial discretion would not be used in such an abusive fashion?
So the act itself under Section 3 indicates that a person can be convicted not less than 7 days after a first conviction. And so that means that hypothetically, it could be more than 7 days, but it could be 8 days, 10 days, 20 days. Hypothetically, somebody could face repeated fines on end until a person finds themselves not in noncompliance. With respect to prosecutorial discretion, the court in Nur was clear that relying on that kind of discretion is not appropriate in order to save an otherwise unconstitutional law. Prosecutorial discretion is very difficult to review. It can only be reviewed on abusive process and is simply not an adequate protection against the harms of mandatory minimums.
If I could, I'd like to take you back to your overbreadth argument, because I don't feel that I have a strong sense of why the Bedford standard is met in your argument. That's a very strict standard. That's no rational connection with any or some of the objectives. And why do you say that test is met here?
The Bedford standard is that there's no rational connection between the objective and some of its applications. And so certainly there is a rational connection overall between requiring people to get vaccinated and fulfilling the objectives of the act. But the particular instances of arbitrariness here are, for example, that Mr. Yuno can sit in his basement, order all of his groceries, not interact with anyone, and yet he faces fines in jail, whereas a medically exempt person, all they have to do is self-isolate and they're unvaccinated too. So those two people pose the exact same risk. And Mr. Yuno has very significant reasons for making the choice he has made, yet the act treats them differently for no good reason. That's one example of the arbitrary applications. For people like Mr. Yuno, they're not going to change their mind about whether or not to take it. His testimony on the charter application was clear that this is a fundamental choice that he has made. And as a result of the act, punishment becomes a permanent condition of his life, at least until the act is repealed and at least until herd immunity is achieved. Not only is he going to face mandatory minimum fines, which will undoubtedly escalate over time, but he's also eventually going to end up in jail. And I'd like to turn to my submissions on imprisonment now, unless there are any further questions about fines. They are at paragraph 42 of the appellant factum, and our position on jail is twofold. First, jail is a grossly disproportionate penalty for this particular offense. Imprisoning people for not taking a vaccine is an extreme response. Imprisonment entails a surrender of liberty and personal agency to the discretion of correctional authorities, and as a result, it's supposed to be reserved as a last resort. And the government will tell you, I'm sure, in their submissions that imprisonment will be reserved for repeat and flagrant noncompliance. But on the face of it, the act allows imprisonment on a third offense, which can occur after 3 weeks. Essentially 3 strikes and the person can go to jail for refusing to take a medical treatment, which is a charter protected interest.
But on the record before us, Ms. Pasca, am I right that no one has been imprisoned to date?
That's correct, Justice Sossin. Nobody has, but people will be. Mr. Yuno is going to jail. He's not going to change his mind. He's not going to be deterred, and eventually he will end up there. There are other people, for example, who may have conscience or religious-based exemptions to vaccination, who could fall into the repeat and flagrant noncompliance category because they also won't change their mind for very good reasons. They are also likely to end up in jail. And so the reasonable applications of this law suggest that the government eventually will resort to this penalty.
If you're assessing, if you're alleging that it's a disproportionate penalty, don't you have to take into account the context of the offense? So Mr. Yuno's offense isn't just, it doesn't just impact on himself, it impacts on the community around him. The point is that he is increasing risk to the people around him, not decreasing risk by exercising his rights. And so any analysis of how disproportionate the penalty is has to take that larger picture into account, not just the impact on him, doesn't it?
That's certainly true, Justice Morgan, but fines are sufficient to take that into account. I would like to stress that the offense under Section 3 is just being unvaccinated. It's not deliberately exposing yourself to others. It's not coughing on people. It's not even entering public spaces. That's not what's being regulated. It's just the fact of existing in Flavel without having taken this medical treatment. And that is what is so grossly disproportionate, that there is no connection at all between using jail for that type of infraction and the ultimate aims of the law.
May I ask if your argument is sort of overbreadth or an arbitrariness and the penalty sections? In the remedies that you seek, you speak to a particular remedy in terms of striking the penalty of imprisonment and the minimum fine. So kind of 2 questions on that. So if the minimum fine was struck and imprisonment was struck, you would say this is proportional, this is not arbitrary?
If the penalties were struck, the act would still be overbroad, and so it would need to be substantially redrafted in the ways that my co-counsel will suggest in her submissions. But there would not be any gross disproportionality issues because those issues really arise from the mandatory minimum and the possibility of jail.
Thank you.
If there are no further questions on the Section 7 submissions, I will leave you with this. The right to control your own body is a fundamental interest. It should be protected even in the context of a pandemic, and I will leave it to my co-counsel to explain why such a significant violation cannot be justified in this context. Thank you.
Thank you, Ms. Pasca. Ms. Eng?
Good evening, Justices. Even in this time of emergency, forcing a medical treatment on people against their will goes too far. While achieving herd immunity against the HRSA virus is a pressing and substantial objective, the Vaccination Act is so deeply coercive and flawed that it fails at each remaining stage of the Oakes analysis. This court has never upheld a violation of Section 7 under Section 1, and it should not do so today. At the heart of this appeal is a piece of legislation that goes—
intervene and ask you this. You said we shouldn't do so today, but within that admonishment or that practice is clearly the idea that exceptional circumstances can sometimes exist. And what can be more exceptional than a pandemic where everybody's threatened?
The HRSA pandemic is an exceptional circumstance, and the court in cases like the BC Motor Vehicle Act reference acknowledged that these kinds of situations, war, epidemics, and the like, might provide those circumstances necessary for a Section 7 violation to be justified. But that is not the end of the inquiry. And the fact that the government is legislating in response to an emergency calls for some deference, but does not lead the court to the point of failing to scrutinize the legislation. And in this case, this was not a proportionate response. Ultimately, the act goes to what was effectively the most coercive option available when it simply didn't have to.
Ms. Eng, can I just ask a question though in response to that emergency pandemic? Isn't it fair that overreactions are sometimes necessary when the science and the policy are uncertain? For example, a complete lockdown of the whole of Faulkner or Flavel, when we know there might be certain regions where the risk is very low. But that overreaction is, from a public health point of view, going to result in a quicker end to what is collective suffering on an unprecedented scale. So isn't there room for overbreadth, overreaction in emergency circumstances that we would otherwise bring much stricter scrutiny to?
Some deference is appropriate, Justice Sossin, but on the evidence that was available at the time, the government did not need to deprive people of liberty and security to this extent. And that takes me directly to my submissions on minimal impairment. And those begin at paragraph 60 of the appellant's factum. As the court held in Hatarian Brethren and affirmed more recently in Carter, the respondent must show the absence of less drastic means that are capable of achieving the government's goal in a real and substantial manner. And here that goal is achieving herd immunity through sufficient vaccination coverage. As Justice Abraikovich held, there are less impairing alternatives that are capable of achieving herd immunity without this level of rights deprivation. And my submissions focus on two alternatives in particular. First, the system of vaccination cards that the government of Flavel has implemented alongside the Vaccination Act to assist in enforcing it. And second, allowing for non-medical exemptions within a broader mandatory scheme. And I'll start with the vaccination cards.
Zen, can you just help us out for a moment with the standard we're applying in this minimal impairment analysis? Are we looking for, again, gradations of less intrusive conduct that could achieve the objectives, or are we looking at whether what the government chose is a reasonable choice among the alternatives?
We are focused on whether there are alternatives that are capable of achieving the objective of reaching herd immunity. And this does not need to achieve the government's goal to exactly the same degree as the government's chosen approach as the court held in Hatarian Brethren. So the focus is on the viability of the alternatives. The government of Flavel has instituted this system of vaccination cards, whereby each person who gets vaccinated receives their proof of vaccination, and each person with a medical exemption gets a temporary card listing the date of their most recent negative HERS test. They can then be denied entry to public spaces like a restaurant or a retail store if they are unable to produce one of these cards. But the government of Flavel didn't stop there. It took the extraordinary additional step of making it an offense to simply be unvaccinated, regardless of a person's conduct or the particular risk they might pose to others.
Is it clear that the testing is reliable? That is, if you have a card that says that you're exempt from vaccinations, but you've had a test X number of days ago, how much more is that? More or less, is there evidence on that? More or less reliable than having had a vaccination itself?
The regular test.
And how do you factor that into your analysis? That is, if the tests are not as reliable as the vaccines, then how is the card going to accomplish the same task as mass vaccination?
The regular testing that is required for people with medical exemptions is a risk mitigation measure. It does not eliminate the risk entirely, but that can also be said for the vaccine itself, which is only 73% effective. The benefit of the card system in particular is that it prevents people from interacting with others in the community where they might pose a transmission risk. So in that way, it is more tailored to the actual mischief that Parliament is trying to address, which is the spread of the virus, because people who are unvaccinated will not be able to put others at risk.
But don't we go beyond that from what the government says are its objectives? I mean, that is clearly one of them. But they go further and suggest that there's economic and social objectives at play, where they don't just want to reduce the risk of people infecting each other. They want to, in some ways, create a situation and a society in which people can go out and participate as economic actors, as people, as part of a community. What do we do with that part of the government objective?
And people who get the vaccine absolutely will be able to resume normal life. And that is the primary incentive that this system offers. Ultimately, we are talking about emergency measures. Both the Vaccination Act as well as the alternatives the appellant is proposing are designed to get us out of this crisis. This is not what the statutory scheme is intended to be 5 years from now. So we are reducing the current crisis to below emergency levels, because realistically, on a vaccine that is 73% effective, HERS will always be part of our lives. The nature of the scheme is very similar to the Vaccination Act in that they both promote a mass wave of vaccination before a prescribed cutoff date, at which time the access restrictions or the penalties under the Act come into effect. And this is what yields that significant increase in the vaccination coverage rate. And that specifically targets those people who may be hesitant and need an additional push to get the vaccine. But it is different.
Sorry to interrupt that, Ms. Eng, and I'm going to take judicial notice of the widespread supply of vaccines so that all of these options can allow for as much vaccination as possible in as short a time. But if you accept the need for the nudge or the push, isn't government in the best position to determine what the appropriate nudge or push would be? And haven't they done that in the current choice that they've made in the structure of this act, with the fines and imprisonment possibility together with exemptions where there's a medical basis or for small children?
The scheme of penalties under the Act is extremely coercive and ultimately was not necessary. There is no evidence in the record as to why a scheme as restrictive as the vaccination card system was not enough to get us to this point. Further, the scheme of penalties, particularly the mandatory fines, has a disproportionate burden on low-income people in particular, who are more likely to be caught by the act in the first place due to socioeconomic barriers in accessing the vaccine that are themselves distinct from the government's ability to supply them in the first place. But critically, the vaccination card system does preserve an element of choice for those Flavelians who are so firm in their convictions that they would be willing to accept that level of restriction in their lives until we are able to get out of this crisis. Unless there are further questions on the vaccination card system, I can turn to the system of non-medical exemptions.
Well, may I just kind of ask a question that ties in with the arguments that you've made on the vaccination cards? And that is that Section 3 does not minimally impair the right to liberty and security of the person. Now, my understanding is that the respondent has conceded, in essence, that there's a deprivation of liberty and security of the person. But as a court, how can we, with that concession, do we need to go into the depths of that deprivation to do a proper Section 1 minimal impairment analysis?
Yes, Justice. The deprivation at issue here is taking away the right of nearly every person in this country to make a medical choice, and that is incredibly significant. It's also important at the Section 1 stage to take into account that people's reasons are not just in the nature of making a medical choice, but also intersect with other charter-protected rights, including freedom of conscience and freedom of religion. And to fail completely to accommodate those differing views within society is a significant deprivation that was not necessary in these particular circumstances.
Can I ask, have you given thought, though, to the idea, to the prospect that using the card as the major tool in the government's regulation of this it stigmatizes people. It stigmatizes people like the challenger here, right? That is, it requires much more flashing of the card. Every shopkeeper is going to have to now card people before they come in. Every taxi driver, every bus driver. There's, you know, carding someone to see if they're vaccinated or not vaccinated, or if they're they've had a recent test or haven't had a recent test, and what the result of that recent test is very public and is very stigmatizing. And so it carries with it another harm that some people may, you know, maybe this particular challenger doesn't mind, but other people in the same boat who have some kind of conscientious objection to the vaccine, but don't want to advertise it either. They're suffering a stigmatization that is unnecessary if there's basically, if one can rest assured that virtually everyone in the society, everybody getting into the taxi, everyone coming into the shop is going to be vaccinated.
Yes, Justice, this scheme is very intrusive, and in a perfect world, vaccination would be entirely voluntary. But the vaccine card system was rolled out by the government as a necessary element of enforcing the Vaccination Act. That is, there's really no other way to tell whether or not an individual is complying with the vaccine mandate absent a system similar to this. The issue at the minimal impairment stage is that the government imposed this level of restriction, and then it went further and deprived people fully of the right to refuse this medical treatment and subjected them to grossly disproportionate penalties if they failed to comply. And I can turn to non-medical exemptions now, unless there are further questions on the cards.
Thank you.
Allowing for a system of non-medical exemptions within a broader mandatory scheme preserves the urgency and the deterrent elements of the current act. People would need to take positive steps to get this exemption, Otherwise, they would be subject to the same mandate as everyone else on the same timeline as everyone else. This also acts as a filter, preventing people whose hesitance is only minor from obtaining an exemption like this and going unvaccinated. This would also virtually eliminate the risk that people could avoid or delay vaccination due to carelessness, which is one of the motivating rationales behind the Vaccination Act. The proportion of Flavelians who are likely to obtain an exemption like this is very small and does not bring the population below the level required to achieve herd immunity. Justice Abrakovich expressly considered the expert evidence and concluded that Flavel could have a tailored non-medical exemption and still achieve herd immunity. It is only 2% or less of the population that is firm in their opposition to vaccines. And some of these people, as Dr. Sukumar's evidence indicates, may already be entitled to a medical exemption. Yet more of them may have already contracted HERS and under the current act would also not need to be vaccinated anyway.
But wouldn't your argument be simply setting up another arguably arbitrary or overbroad scheme? In other words, to the person who isn't in that 2%, the person Justice Morgan was referring to, who might have less strong, more hesitant reasons, isn't quite ready yet. Should they be compelled to take this treatment when they're not ready on force of penalty or imprisonment, while Mr. Yuno and others who are card-carrying objectors would be in that other category along with the medical exemptions of people who are given the choice? So where you draw the line in your alternative, isn't it still problematic for the very reasons your co-counsel listed for us?
It is unlikely that someone who does not feel very strongly about whether or not to get the vaccine would go through the trouble of obtaining an exemption like this. And it could be a not altogether trivial requirement. For example, in Ontario, with respect to the Immunization of School Pupils Act, parents have to swear an affidavit that they have a religious or conscience-based objection to having their child vaccinated. And that itself provides a measure to assess people's sincerity when they apply for an exemption. So
while it's not in the parts of the record that I recall, there's also been significant growth in the numbers of parents in that category, that once there is an exemption, it's not necessarily just a stable amount of people. There may be others who, like Justice Morgan suggested, see this now as their loophole. So at the end of the day, isn't it true that it's no longer a mandatory scheme once you have an indeterminate number of people who are able to access the exemption simply by saying that they're of that view or of that belief?
No, Justice. It is fundamentally different from a mandatory scheme. And in these compelling circumstances, it would be open to the government to place restrictions on who might be able to access this exemption. What we don't have is evidence that the number of people eligible for a tailored non-medical exemption would actually take us outside of the required threshold. And absent that information, the government could have accommodated these people and their fundamental beliefs, and it simply failed to do so on this scheme.
What about the argument, though, that it did precisely that in defining the medical exemption so broadly as to being maybe detrimental to the health of the person? And health could be physical health, could be an allergy, but it could also be psychological health. That's part of the security of the person interest under Section 7. So why isn't a broadly framed medical exemption proportionate?
The medical exemption for physical detriments to health is very broad, but for psychological harms, it's very narrow and requires a DSM-5 diagnosis, which Mr. Yuno, for example, does not have. And yet his panic attacks, his anxiety are not given recognition under this scheme, nor is somebody's personal a connection with God, somebody's conscientious objection to modern medicine, these are categorically subordinated under the government's chosen approach. And
sorry, no, continue. Finish your answer first. I have a follow-up.
I was going to move on to my conclusion, unless there are further questions on the alternatives.
I want to ask you one thing, because you raised it. I don't know if you have, if any thought has been given to this, but you raised the issue of school children and registering for school. I take it that the parent as guardian gets to choose whether the child is vaccinated. We're talking about children between the ages of 4 and 4 and up. Doesn't Section 7 also protect the child's right to medical care? And isn't it's one thing for the challenger to want to increase the risk on himself. That's already controversial. He's increasing also the risk of people that he comes in contact with. That's even more controversial, but he's directly increasing the risk of a child that's in his care, that he's the parent or guardian of. How far does his right go before somebody else's right to medical protection kick in? And on that point, I'm not going to call it up because we don't have time, but there are multiple perspectives on Section 7 and medicine. If you look at the Morgenthaler case, the 1988 Morgenthaler case, Justice Wilson took your position, that it's about liberty and choice. But Justice Betts, the other judgment in the case, Justice Betts had a different view. His view was that he also would strike down the law, but he struck down the law because people are entitled to medical protection, which he thought that the law's procedural requirements denied women who sought an abortion. So Section 7 covers the right to medical protection, not just the right to medical choice, doesn't it?
Yes, Justice. And the key issue here is that it was possible to protect the vulnerable. It was possible to protect children. It was possible to protect those who are medically unable to be vaccinated without requiring this level of a deprivation on the liberty and security rights of people like Mr. Yuno. The government has simply gone further than necessary in the name of an objective that it may not even achieve. The right to make your own medical choices is fundamental in a free and democratic society. And this level of forced medical treatment on an unprecedented scale was not necessary to get this pandemic under control. This act is unconstitutional and it should be struck down.
Thank you very much, Ms. Ng.
Thank you.
We could move then to the respondents.
Good evening, Justices. My name is Geri Angelova, and with my co-counsel, Ms. Hana Awwad, we represent the respondent, the government of Flavel. Justices, we find ourselves living in precarious, unprecedented times. These extraordinary times call for extraordinary measures. The HERS pandemic has already had devastating effects on humanity, resulting in over 800,000 deaths worldwide and counting. Now, with the discovery of an effective vaccine, time is of the essence. It is imperative to act now and ensure maximum vaccination coverage to prevent countless more Flavelians from losing their livelihoods, their businesses, their homes, and most importantly, their lives. The Vaccination Act will help achieve just that. I will present the government's submissions on why the Act accords with the principles of fundamental justice under Section 7, and my co-counsel will then turn to address why any deprivation of the appellant's Section 7 rights is nonetheless justified under Section 1. The government's submissions on Section 7 can be found at paragraph 26 of the respondent's factum. The appellant has not met his burden under Section 7 for 3 reasons. First, the vaccination requirement is not overbroad because it is reasonably necessary to achieve its objective, namely to achieve herd immunity as soon as possible. Second, the fines under the Act do not rise to the high threshold for gross disproportionality under Section 7, in light of the jurisprudence on cruel and unusual punishment under Section 12. Third, the availability of imprisonment for recurring non-compliance with the Act is neither arbitrary nor grossly disproportionate. Turning first to the government submissions on overbreadth. The vaccination requirement is not overbroad because the appellant has failed to show that there is no rational connection between the purpose of the vaccination requirement and any of its effects. The first step in the overbreadth analysis is to properly identify.
My understanding is that's a precedent, but doesn't that standard undercut the whole notion of overbreadth, because it says it insists on no rational connection, so nothing logical, nothing that would meet that, and with any or some of. So as long as we can provide some kind of linkage to one of maybe the subsidiary goals or objectives, that's sufficient as a bulwark, as a constitutional standard. Why should this court accept such a low standard on rational connection?
The standard for rational connection is low because a measure of deference must be paid to the means chosen by the legislature, especially in the overbreadth analysis. This is because the government should be open to make policy choices, especially in times of a public health emergency. And so the standard is high because it is not for the court to intervene where a decision, a policy choice has been made in a time of emergency that could effectively achieve its objective, even though the judiciary may find another means available that could achieve the same objective. The relevant objective for the purposes of both Section 7 and Section 1 is the objective of the specific provision at issue, and not the broader objective of the entire legislative scheme as a whole. In Moriarty, the Supreme Court of Canada held that an animating social value would frame the statement of purpose at an overly high level of generality. So while the appellant found a formulation of the legislative objective as protecting the public health does reflect an animating social value that underlies the legislation, it does not reflect the precise objective of the vaccination requirement under Section 3, Sub 1. When determining the specific objective, the Supreme Court of Canada in Safarzadeh Mercalli directs the court to consider three different sources. First, we must look to the express legislative purpose, which in this case is to protect the public health. However, the inquiry does not stop there. Second, we must turn to look at the context in which this legislation situates itself, which is a global pandemic, where it is especially imperative to take immediate ameliorative action. Third, we must also consider any other relevant extrinsic evidence. In this case, we have a statement from the Minister of Health, where Dr. Tessier said that timing is of the utmost importance in controlling the future spread of HERS.
But Ms. Angelova, don't you also have expert evidence that there is a substantial number of community members, for 2% in the evidence, who won't accept vaccinations and may well be driven underground if threatened with fines and imprisonment, and may pose a greater barrier to achieving herd immunity? And we've heard about other distinctions between how those with medical exemptions are treated versus those conscientious objectors who are not exempted. And of course, a fairly arbitrary line drawn in young children between those who are 4 and those who are 5, or 3 and those who are 4. So isn't in all of these cases the government accepting some barriers to achieving herd immunity, but not others? How can that be explained?
Yes, Justice, and the government in this case did have to draw some bright line rules. However, those rules and those decisions were made on a rational basis. I will begin by addressing why we could not expand the exemption beyond what is medically necessary. An ideological or personal beliefs exemption, unlike a medical exemption, may not be dispersed evenly throughout society. and individuals that have similar ideological beliefs are more likely to frequent the same public places and live in the same neighborhoods, which would place those communities at a heightened risk of future outbreaks. For children, while we do not have precise evidence on the record, in the analogous context with COVID-19 and other jurisdictions, the vaccine simply has not been tested on young children to date. So the government of Flavel...
I'm just going to ask you, is there some evidence in the record of that, the geographic disbursement of people who hold anti-vaccination beliefs?
Not precisely in the record, Justice Morgan, but this is something that we could take judicial notice of, knowing that people frequent the same churches that have the same ideological beliefs, and also attend private gatherings with individuals that share their same worldviews.
Okay, it's an interesting thing to take judicial notice of, but I'll accept that for now. Thank you.
Thank you, Justice.
Well, can I follow that up and say, well, if that's your argument, wouldn't the individuals in this community then, I mean, if they become ill, can we take judicial notice that there's a theory that says that the antibodies lead to herd immunity as well? And what we're doing there is two variants to herd immunity.
Of course, Chief Justice Martin, we can't achieve herd immunity by just continuing to let this pandemic run its course. However, that would come at too high a cost to society. And in response to your earlier question, Chief Justice Martin, this timeliness component of the legislative objective does not merely reflect the effectiveness of the act, but it goes to the heart of what the government of Flavel is trying to achieve here. And that is to quickly curb the spread of HERS in order for us to achieve herd immunity as soon as possible without suffering any more needless harm or suffering as a result of this pandemic. The fact that the Act does not provide for an individualized risk assessment, as my friends suggest, does not make it overbroad for three reasons. First, there is no evidence to suggest that those who are staunchly opposed to vaccination are more likely to abide by social distancing measures. Second, even if they were to do so, we must remember that the precise objective of this specific provision is to achieve herd immunity and not just to protect the public health more broadly. Adherence to social distancing measures alone simply does not provide for a viable long-term solution to this pandemic. Even with the social distancing measures currently in place, we know that the current new cases can range up to 2,000 on a daily basis.
Ms. Angelova, isn't though that a different kind of arbitrariness, that the fact that the vaccine chosen by the government happens to have a fairly low efficacy rate means the proportion of the population has to be higher, and as a result, the choices of Mr. Yuno to control what goes into his body are going to be affected. So isn't there something arbitrary about picking a herd immunity number that is a product not of a balancing of Mr. Yuno's rights for autonomy, but simply a choice made with respect to a particular vaccine's rate of effectiveness?
The government simply doesn't have the luxury to wait to see if we can develop a more effective vaccine. And the government has to play with the hands that they've currently been dealt. And while that may have an adverse impact on individuals' right to medical choices, that impact is hindered and lessened by the fact that an individual's right to make medical choices has only been protected in other cases where the impact of that decision only has an effect on that individual. In this case, we are working towards not only upholding Mr. Yuno's Section 7 rights, but ensuring that there is sufficient protection afforded to the Section 7 rights of others. And in that sense, the line drawn has not been arbitrary. If there are no further questions, thank you, Justice. If there are no further questions with respect to the government submissions on overbreadth, I'm happy to turn to discuss why the fines under the Act are not grossly disproportionate. The government...
This is a strict liability offense?
Yes, Justice. So this offense, my friends and I agree, is a strict liability offense where there is the availability of a due diligence defense for those individuals who do take reasonable steps to get vaccinated, but are simply unable to do so for, let's say, logistical or financial reasons. And that is one of the things that distinguishes this case from the case of Boudreaux. In Boudreaux, the mandatory victim surcharge that was found to constitute cruel and unusual punishment applied automatically and universally on top of the other punishment for any given offense. And it was applied regardless of the severity of the crime or the characteristics of the offender. Here, that is not the case. The penalties under the Act and the fines are the only penalty imposed on a person that contravenes the Act who has no reasonable excuse for doing so.
But wouldn't you accept that that impact varies greatly depending on someone's income? And why should that be? In other words, $1,000 may just be an expensive speeding ticket for a privileged member of society who's entitled to then follow their conscience, and this is the price of doing business. A low-income individual has no such luxury, and that creates significant disparity with no obvious public policy rationale, at least that I could see in the record.
Yes, Justice. The government concedes that this fine may have a disproportionate impact on low-income communities. And while the $1,000 mandatory minimum fine is high, it must be so. In order for this law to have a deterrent effect, the penalties must be sufficiently severe and certain. That's why we have a mandatory minimum set at such a high amount. As you alluded to earlier, Justice Morgan, a finding of unconstitutionality with respect to this particular mandatory minimum fine could bring into question the constitutionality of other mandatory minimum fines that also have a disproportionate impact on low-income communities, but are necessary in order for the law to serve its deterrent intended effect.
Well, not that I want to flip my position, but doesn't it, in the context of a constitutional challenge like this, doesn't this have a certain aura of people being able to buy their rights? Some people can buy rights and some people can't. There's a more crass variation on what Justice Sossin has been saying. That is, the privileged can easily afford a $1,000 fine and others just can't afford it at all. But when it comes to fundamental charter rights, is it appropriate for the government to say you can buy your way into them and out of them?
No, most definitely not, Justice Morgan. However, this $1,000 mandatory minimum fine is precisely that. It's the minimum. Judges still have discretion to award fines up to 20 times that amount if they feel that a person is able to afford that, in order for that fine to have a deterrent effect on that particular individual that may happen to be more wealthy and could afford to potentially pay their way out of non-compliance. So this has been contemplated by the Act.
And does that mean your position is if the scheme was simply up to $20,000, let's say, but no minimum, and it was up to an individualized assessment to determine the fine, that it would have less deterrent effect? In other words, to give discretion, but still have an eye-catching upper maximum, do you think that would, is the government's submission that would not have the same deterrent effect?
Precisely, Justice Sossin, because it's not sufficiently certain what the fine would be. An individual could gamble with non-compliance, not knowing whether they'd be subject to a $5 fine, for example. So in order for the law to have a sufficient deterrent effect, it must be that the penalties under the Act will be certain, at least with respect to the fines. The appellant under this stage has simply failed to show that his individual Section 7 interests are enough to outweigh the state's pressing and substantial objective of protecting the public health.
But is it his interests, or is it the interests also of a hypothetical individual who could never afford a $1,000 fine?
We can consider interests of those that may be similarly situated, but given that it's Mr. Yuno that's brought this challenge, the focus should be on the impact on him as the individual that's raised these concerns. But with respect to other individuals that cannot afford this fine, the indefinite spread of HERS and the continued lockdowns that follow could have even more devastating economic consequences for individuals from low-income communities when compared to the fines under this Act. As such, it simply cannot be said that the fines under the Act are so abhorrent or intolerable to society in order for them to reach the threshold for gross disproportionality under Section 7.
But what about the fines in conjunction with potential imprisonment?
I'm glad you asked, Chief Justice Martin. I'm just about to turn to my submissions on imprisonment. The government's position is that the mere availability of imprisonment under the Act is neither arbitrary nor grossly disproportionate. Imprisonment only becomes an available penalty under the Act after 2 previous contraventions, and even then, it remains discretionary.
Ms. Angelova, I'm a little confused by the penalty of imprisonment in this context. Normally, we think of imprisonment as removing someone from being able to cause risk to society, but a pandemic knows no borders or offenses, so the prison is the exact same risk community. And in fact, we have evidence on the record suggesting it may be greater than elsewhere. So putting someone from their home or the community into prison makes absolutely no difference from a herd immunity point of view. So I don't get the connection of how imprisonment creates an effective removal of that risk of that individual from society or potentially harming others, which is normally what we see imprisonment to be for, in addition to other goals.
Of course, Justice Sossin. In this case, imprisonment does not only serve the purpose of incapacitation, it also serves the purpose of deterrence. And it goes back to Justice Morgan's earlier question that having imprisonment on the books as an available penalty will ensure that those people who think that they can just pay their way through noncompliance have a higher, more severe penalty to deter them. But with respect to putting people in jail, the appellant has not presented any evidence to suggest that the risk of contracting or spreading HERS is higher in correctional facilities than among the general public. Under the Act, all residents are going to be subject to the same vaccination requirements, including inmate populations. As such, there is no reason to believe that the risk of contracting HERS would be higher among one predominantly vaccinated population than among another.
And you concede that there's also no evidence it would be lower, and obviously congregate settings create higher risk than non-congregate settings. So it doesn't seem that controversial to say there's certainly nothing about imprisonment that advances the public health goals. And I take your submissions on the potential deterrence, but it does seem to be a different form of risk that we're dealing with in this case.
On the point about us not having any evidence about whether the risk is lower, that would have to be determined on a case-by-case basis with reference to a particular institution. And as I see that I am running low in time, if I could just ask for a brief indulgence to fully answer your question, Justice Sossin, and briefly conclude.
Quickly.
Thank you. We have evidence that in another institution in the COVID-19 context, the risk was in fact lower because it was such a highly controlled institution in that case. And the appellant would have to raise evidence on this point. But to conclude, Section 7 rights are not absolute justices, but must accommodate the corresponding rights of others, especially those most vulnerable. Subject to any further questions, Justices, I will now cede the screen to my co-counsel who will address the government's submissions on Section 1.
Thank you, Ms. Angelova. Ms. Awwad.
Good evening, Chief Justice, Justices. The appellant's Section 7 interests on this appeal conflict with the interests of vulnerable Flavelians who are medically unable to be vaccinated and must therefore rely on society to protect their health and personal security. These interests, along with the severe social, educational, economic, and health costs of this pandemic, are properly considered under Section 1. Before proceeding to the government's submissions on Section 1, I'd like to make a brief preliminary point on the nature of safety regulations. As Justice Sossin alluded in his question to my friend, safety regulations by their very nature require the government to err on the side of caution. In the Queen and Michaud, the Court of Appeal for Ontario emphasized that a regulator may choose a proactive bright line rule in preference to a general behavioral standard, even though such a rule is usually over-inclusive and errs on the side of safety. This is a legitimate and reasonable use of governmental authority, and Parliament is entrusted with this responsibility, especially where the line drawing exercise is inevitably somewhat discretionary. At section 1, our submissions begin at paragraph 55 of the respondent's factum. I will spend the bulk of my time arguing that the law minimally impairs the appellant's section 7 rights before moving to the final proportionality stage, but I would be happy to address any questions that the court might have on the pressing and substantial purpose or the rational connection.
At this point, I would just like you to address somewhere, if we do find that there is a gross disproportionality under section 7, does that change at all how you approach your section 1 analysis? Because there's other ways we could say that it's infringing of section 7.
Thank you, Chief Justice. If this court finds that the law is grossly disproportionate at the section 7 stage, it could still be saved under section 1 because the proportionality analysis under section 7 weighs different interests from the proportionality analysis under section 1. In Bedford, the Supreme Court of Canada set out a highly individualized approach to section 7 that all but displaces any considerations of the societal interest from that analysis. Post-Bedford jurisprudence must therefore take a robust approach to the section 1 analysis to account for the competing interests that the government must balance when addressing a complex social problem like this one.
Thank you.
Our submissions on minimal impairment begin at paragraph 68 of the respondent's factum. To show that the Act minimally impairs section 7 rights, Flavel must show that it falls within a range of reasonable policy alternatives. As the Supreme Court of Canada held in Hatarian Brethren, section 1 of the Charter does not demand that the limit be perfectly calibrated, judged in hindsight, but only that it be reasonable and demonstrably justified. This vaccine is a collective response to a collective problem. There is no sufficient risk mitigation that the appellant and other individuals who choose to remain unvaccinated could undertake that would be as effective as herd immunity. This vaccine mandate is necessary because the appellant is risking more than just his own health by remaining unvaccinated. Should he contract this fatal virus, he's not just risking his own health, but also that of anyone who might come in contact with him. He also risks contributing to the stressing of our healthcare system beyond its limits and to necessitating restrictions on everyone's freedom of movement.
But Awwad, are those really engaged as we're looking at the alternatives presented by the appellants? Certainly one option includes a possibility of further coercive measures if by a certain juncture of time herd immunity is not achieved. But of course, if herd immunity is achieved by the ability to vaccinate large swaths of the community, aside from this, we'll call it the 2%, why shouldn't that be a less intrusive but still effective means of achieving the legislative purposes? In other words, if herd immunity is the goal, why not allow that opportunity to see if it can be achieved without the intrusion in such a fundamental area as bodily autonomy?
I'll make 2 points in response, Justice Sossin. First, to clarify the proportion of the population that would remain unvaccinated if it were not mandated. The evidence accepted at the application suggests that that proportion of the population is potentially as high as 30%. Dr. Eddie Heddy's evidence, which was accepted by Justice Ibrakovich, suggests that there is a large and diverse portion of the population that is likely to refuse the vaccine if it were not mandated, and also notes that this pandemic has coincided with high and increasing rates of vaccine opposition and hesitancy. So the question here is not merely 2% of the population, it is potentially much, much higher. Second, any proposed alternative would need to give sufficient protection to the government's objective of achieving herd immunity as soon as possible. And both of the appellant's proposed objectives fail to do so. I can take you to our submissions on the first proposed alternative, which is the reliance on the vaccination card system. This system would fail to realize the goal of achieving herd immunity because it would remove the deterrent effect of fines and the possibility of imprisonment. Given the high levels of vaccine hesitancy, Flavel cannot achieve herd immunity without attaching significant fines to noncompliance. The appellant's own expert evidence, Dr. Sugumar, found that provinces in Flavel that have mandated vaccines, but only attached the penalty of restricted access to public spaces, did not see an increase in vaccination coverage and have vaccination coverage rates on par with the national average. It was therefore—
Right, I'm not sure I followed that. Why wouldn't the carding system be able to go with the same severity of penalties if you violate something in the carding system as you've got now? It would at least allow. I mean, as it stands now, we're talking about minimal impairment. As it stands now, it's maximal impairment of his rights. There is no way he won't have his rights impaired. Whereas if you had a carding system, there would be some give in the system. You could also have penalties for infringement of that carding system. Those don't logically contradict each other. But at least there would be something there for him, whereas now there's absolutely nothing there for him to protect his rights.
The vaccination card system is already included in the Vaccination Act. Section 3 requires individuals who are vaccinated, they're issued a card and may be required to present it. In fact, in this case, Mr. Yuno was apprehended because he failed to show proof of vaccination when he was entering a grocery store. The difference between the vaccination scheme that the government has legislated and the alternative that the appellant has proposed simply comes down to what penalties are associated with noncompliance. In the appellant's alternative, noncompliance would simply be met by turning the appellant away from the grocery store and restricting his access to other public spaces. There would not be any fines, there would not be any imprisonment, there would not be any regulation of private gatherings, and there would be no way for the government to ensure that herd immunity is achieved. By contrast, the Vaccination Act requires certain penalties if someone is found to be in contravention of the act. It does not simply delegate the government's responsibility to grocery store owners and coffee shop owners in order to enforce this act. If there are no further questions on the appellant's first proposed alternative, I'll address the second, which is the inclusion of non-medical exemptions in the Act. The addition of a non-medical exemption is unfeasible because it is likely to lower the vaccination rate in Flavel below the level required to achieve herd immunity. Given the low efficacy rate of this vaccine, Flavel would need to achieve near universal vaccine coverage in order to achieve herd immunity. And Dr. Eddie Heddes estimates that 5% of Flavelians would be unable to be vaccinated for medical reasons. Flavel simply cannot afford to expand the proportion of unvaccinated individuals beyond what is strictly necessary for medical reasons. In addition—
Can I go back to the question that I asked previously about the medical exemption relates to health? And yes, there is something that another provision that speaks to, I guess, a mental condition that is in the DMS, but they're not mutually exclusive. So why we as a court have an obligation to read your legislation with constitutional integrity and in conformity? Why wouldn't we read health broadly there to say that someone with the presentation of Mr. Yuno, his health would be impaired if forced to take this because of his prior experience with Mumpella.
The structure of the Vaccination Act in our submission rightly delegates the responsibility of assessing who has sufficient medical reason to be exempt to the medical community. Doctors and other healthcare professionals are required to present a report that exempts someone from vaccination. On the evidence, Mr. Yuno has not sought a medical exemption. He believes that his own symptoms would not be consistent with a DSM-5 diagnosis. And he has a general distrust of modern medicine that I expect would preclude him from seeking such assistance. However, it would both be unworkable and, in our submission, improper for the government to take the role of doctors and other healthcare professionals in determining who is and is not medically exempt from receiving the vaccine. As it stands, the medical exemption is broad and generous. It does permit individuals to be exempt for psychological reasons or mental health reasons, in addition to exemptions because of physical reasons, as well as previous immunity or previous infection with HERS.
But doesn't that leave us then with a situation where certain kinds of exemptions are seen as legitimate and therefore we can make individualized assessments, whereas for others it falls into this strict liability basket. And again, assuming the proposal we heard of a fairly strict and rigorous exemption category that very few would take on unless they were deeply committed ideologically and otherwise to their objections. What would be lost if that were simply left to an individual determination, as happens in schools and other settings where vaccination coverage is also of critical public concern?
There are two primary differences between the exemptions that exist in schools and those that exist under this act. First, the exemptions that are crafted in schools are responding to vaccines with very high efficacy rates, where it is not necessary to vaccinate everyone. Given the low efficacy rate of the HERS vaccine, Flavel cannot afford to lower its vaccination rate below what is medically necessary. And so Parliament has chosen not to include a non-medical exemption or a conscience-based exemption in the scheme. The second point here is that there's no workable standard that would permit a non-medical exemption in this act and that would permit Flavel to achieve herd immunity. The examples that my friend provided of requiring someone to obtain confirmation of their opposition or to swear an affidavit to that effect does not meaningfully distinguish between those with a staunch objection to vaccinations and those with more casual or insincere objections. The potential of including a non-medical exemption could decrease the level of vaccine coverage in Flavel below what is medically necessary and below the level required to achieve herd immunity. I would also note that at the minimal impairment stage, the government's chosen means of achieving its objective is entitled to significant deference. In this case, the law responds to a pressing and social problem and protects a vulnerable population, namely.
But let me ask you this, it harkens back to Justice Sossin's question. What if we say that the mandatory minimum fine, why is that so crucial when you could have a fine of 0 to 20,000? How is that minimally impairing?
Chief Justice, as my co-counsel stated, the mandatory fines in this scheme are necessary to deter non-compliance with the Vaccination Act, and effective deterrence requires certainty. It would not, this deterrence would not be effective if the potential penalty were a fine of $0 or of $5. The mandatory minimum is therefore necessary to ensure deterrence from non-compliance.
But isn't that the exact same argument with respect to imprisonment, where there is complete discretion? There's not a mandatory requirement to imprison somebody if they don't pay a fine, for example, and the evidence is that no one has been imprisoned. So why is that kind of individualized discretion appropriate with respect to imprisonment, but not with respect to the amount of a fine?
It is appropriate with imprisonment because imprisonment places a much greater limit on the Section 7 rights than a mandatory fine. The government does not take lightly that it has included imprisonment in this act, and it is necessary, given the scheme, for imprisonment to be discretionary.
But isn't the point of mandatory minimum fines that you don't trust the courts to fashion the appropriate level of fines? There's no real reason that fines without a mandatory minimum don't serve a deterrent effect. It's just that the court will have the individual before it and can determine what the appropriate level of deterrence is for that person. Whereas mandatory minimum paints it with a broad brush because for some reason courts aren't trusted. Is that the whole point that the government's trying to make, is that we don't trust the courts to make this determination?
Not at all, Justice Morgan. Simply that effective deterrence requires certainty, and there must be a minimum penalty that individuals know they will be subjected to if they contravene this act. An individual who carelessly remains unvaccinated and who puts others at risk of contracting this fatal virus should know as a matter of fact that they could be liable for a minimum fine of $1,000 if they are convicted under this act. Those who have reason for remaining unvaccinated have a due diligence defense available to them. Justice Sossin.
Yes, I know, sorry to interrupt. I know you haven't reached the last stage of the Section 1 analysis, but I think it speaks to an issue that's been weighing on me, which is the herd immunity by its very name has an abstraction to achieve a level of societal health. But we're balancing that against a very significant and severe individual deprivation of autonomy, and no reason to disbelieve the evidence that this will have a profoundly negative effect in Mr. Yuno's case. And in fact, he won't participate and therefore will be subject to fines and likely imprisonment, at least on the arguments of your friend. So how do we balance the abstract level of benefit with the severe and profound deprivation of this individual's rights?
Seeing that I'm nearing the end of my time, may I ask for a brief indulgence to answer the question?
Please answer the question and then you'll be asked to conclude.
Thank you, Chief Justice. The salutary effects of this act are anything but abstract. The salutary effects include protecting the Section 7 rights of Flavelians who cannot be vaccinated for medical reasons. For that reason, it may be, or in our submission it is in this case, that the public interest at stake is great enough as to outweigh the individual rights of the appellant. We would also submit that the limit on the appellant's right is relatively minimal, given that the only requirement here is that he be vaccinated. Barring any further questions, I'll conclude by asking this court to not let the perfect be the enemy of the good, by stifling promising efforts that would end this pandemic and prevent needless suffering. This appeal should be dismissed. Thank you.
Thank you, counsel, for your able submissions. The court will retire to deliberate and we will return in due course.
The justices are now returning to provide commentary.
Well, good afternoon again. Thank you that the panel has decided that they will reserve judgment on this important constitutional question. And with that, we will move then to some comments and commentary. I think this is called the Grand Moot for a reason. I think what we saw was a grand problem and a grand response to a difficult and balanced problem. It's very nice when the different sides have a balanced challenge, and it's very nice when the issues divide in a way that you really can dig into them, delve into them, and really become a master of the material. And there's no doubt that what we saw here was a mastery of the lower decisions, of the evidence, and of oral advocacy. The FACTA were very good, very organized, and clearly set out what we expected to hear. And based on that and the level of excellence of those FACTA, we decided that one of the things we could really do was to explore some different issues and to test and sometimes even push a little bit. And in a moot, if you're being pushed, it means that the person who is judging the moot thinks you can handle it. So you should never be backing away from it or think, oh my goodness, this is an attack. It isn't. The questions are gifts that let you understand what is troubling the judge. And it is your opportunity to use the gift and use it as a springboard for why you think yours is the better argument. And in all cases, you responded in your own ways to the questions, but you didn't shirk them. You didn't say, you tried to confront them. And sometimes the questions are hard and you may not have an answer that is a superb one. But what we did see is a high level of advocacy. And it is astounding to me that we're dealing with the performance of law students. Yes, people with experience in mooting who have been taught and trained in the analytical skills of law, but to produce this kind of performance, there were many times where I forgot that I was at a moot and just thought I was hearing strong advocacy at the Supreme Court on an issue of national importance. So that's very very good that you could deal with that. And so I think congratulations to everyone involved in this complex process. It is a celebration of mooting and the achievements of many here. So I think I speak for all the bench to say that we were very impressed with the quality of the overall advocacy. And we're not used to always having oral advocacy over Zoom. And we're always looking for how is it different? How is it and it was very, very easy to listen to you. You were very engaging. You made eye contact. Your voices were very good. You were very poised, gracious, all of those kind of things. Nobody got flustered. Nobody was super aggressive on a point. I mean, it was very, very nicely handled in terms of overall performance. And what we thought we would do is that we will, if you don't mind, deal with some individual commentary. And I will start, and I will start with Ms. Pasca. And you had a wonderful opening. Very, very strong opening. All right, a rights-based opening, an assertion. Everything about you gave me confidence from the very beginning when you started that you knew what you were talking about, and you had distilled it down in a very good opening sentence, a couple of sentences that hooked me in immediately. I thought you did, we jumped in quickly. with questions. When I asked the question about does it, what does it matter? And you answered very well, and you explained. You didn't try to put me off till later. You answered it and then you moved on. And I don't think you had any real difficulty moving between questions and going back to where you were in your argument. And that is a very advanced skill. Of course, there's going to be a bit of a time lag between that, because you have to, and on Zoom, it's really hard because I'm not back on the screen nodding, saying thank you for the question. And so don't at all be fazed with that. You did a very good overview. I think that you told us where you were starting at paragraph 30, and you went through and were quite organized, and you signaled to the listener where you were in the argument. And that's very important because you want your listener to feel smart, and you want us to know where we are in the argument and why you're making certain factually based assessments. And does it go, to overbreadth? Does it go to arbitrariness? I mean, you really have to be kind of, I think, very precise about that. But you did, I think, a very persuasive job in terms of constantly getting back to the rights-based analysis under 7 and trying to emphasize your key point, which is that this is a very intrusive legislative mechanism, and it's got to be scrutinized with some seriousness. So those are my comments. What I'll do now, if I may, is turn it over to Justice Sossin and Justice Morgan, and they will give you some feedback as well. All right. Thank you.
Yeah, and thank you, Justice Martin. I echo those comments, both the general ones and Ms. Pasca, some of the specific ones in your case. And I think we shouldn't underestimate how difficult it is to make the arguments you're making in this moment, stepping outside of Flavel for a moment, where vaccine hesitancy is what we're used to seeing as a problem to be solved, not a set of choices to be respected, and where most people, I'm sure, listening and watching tonight would line up in 15 minutes if they were told a vaccine suddenly had shown up in the community center. So I think there was a different uphill struggle for government in the kind of moment we're living through, but a particular one in your case to humanize the choices of Mr. Yuno and what it means effectively to be subject to this intrusion. And I never lost sight of that for a moment in your submissions, in your answers, that human element to what otherwise can seem like a public policy, drawing board design challenge of how to get this right. So I thought it was very effective, and again, never easy to go first. And I thought you spoke with clearly a lot of prep, a lot of poise, and I very much enjoyed it.
Justice Morgan?
I think you got to get off mute, Justice Morgan.
Sorry, I've lost the thread here. I'm giving comments on one of our mooters, or general comments on all of them.
This is on Ms. Pasca, and you're welcome to slip in a general observation as well, of course.
Absolutely. Well, as a general observation, I'm going to start off by saying that all of the mooters did fantastically well, but I'm also going to compliment the authors of the problem, because it's a great problem. It's not only timely and engages people in a way that mooting problems don't always immediately engage them, but it was also well constructed. It was well balanced. It gave each of you kind of an equally juicy, an equally meaty issue to sink your teeth into. It was really well done, and everybody handled it quite well. I think actually, I think that it's quite a large audience. It may be a larger audience than one typically gets in the moot court room at school, because all alumni got this video link, and lots of, I know friends who told me that they're going to tune into this who wouldn't ordinarily come out on a weeknight to the law school. And you handled that with a lot of poise. Ms. Pasca, you had, I was going to say also a great intro. You're the first one up, so but this was nice and clear. And you were also really well prepared for the first question. The timeliness is a means and not a substantive objective. I'm not 100% sure I would agree with you given this problem, but it doesn't matter. That was a good, smooth response, which is what's needed for the very lead-off question. And the lead, you know, as the lead-off speaker, you have a tough role in that regard. I was also going to say you did press the judicial discretion button. That's always a great button to press. Judges, for understandable reasons, you know, dislike mandatory penalties. Governments see a broad swath of population and voters when they consider policy, but judges see the individual in front of them and all of that person's frailties. And I know that it's always a good button to push, saying that there should be more, that there's the elimination of judicial discretion plays well in the courtroom because judges feel strongly about that often. So that was a good line to go with. And as I said, in general, your comebacks to sometimes being peppered with some tough questions were very good. Well done.
Thank you so much, Justices.
We're going to turn now to Ms. Ng, and if I could ask Justice Sossin to start the comments, and just something I'll say at the end, if you want to ask us questions as well, the mooters at the end, after we've given you feedback of something you've tried or something you wondered what our reaction was to it, I'm sure we'll be happy to give you any feedback on precise strategies, all right? But Justice Sossin, if you could please address Ms. Ng.
Well, absolutely, and if Justice Martin's opening observation is true, as I believe it is, that every question is a gift, this must have felt, Ms. Ng, like your birthday, because you got showered with presents early and often, and I think the nature of your task, which is to make sure that you really could dig into those alternative means and start to make the case that really there are ways to achieve this objective that take far less intrusion and not much more effort. And I thought you were particularly effective in not being pushed off that view when Justice Morgan asked you about carding, and again, something that we view as quite harmful, but it gave you an opportunity to talk about the subset of the community that Mr. Yuno is part of, and the ability to create, in effect, other kinds of penalties short of violating medical autonomy and still achieving the goal. And I thought that was very effective. So, you know, you tackled, struck me anyway, as quite a lot of questions, including, you know, this tendency to want to overreact and have you know, as much and as fast as possible to deal with something like a pandemic that is so top of mind. And I think you had to take a step back from that, again, kind of popular zeal in the moment to talk about how we need to be just as and maybe more thoughtful in moments like this, where there's such a propensity to accept intrusions on our liberty. And it reminded me of some of the debates around national security after 9/11, and this idea that things we would normally be up in arms protesting in intrusions and civil liberties, the moment swept up lots of thoughtful people to say, well, this is an emergency and we need to forget about those commitments to civil liberties when this is going on. And I thought you dealt with that impulse really effectively, and again, had an excellent detailed sense of those alternatives, and you didn't have to kind of consult your notes or a prepared text. It's clear you've been kind of living and breathing this problem for a while, and it was very effective, I thought. And I'll turn maybe Justice Martin next, Chief Justice Martin, next to you.
I think now we're okay. I'll go next. I also thought you did a very good job. It's nice to argue Section 1. All right. Section 1 is one of those framework. It has a natural framework, and the law is kind of settled, and it's a good one to do. And you started out with a very, again, forceful statement, and your word choice was completely consistent with your argument, and that's a very high level of sophistication. You said forcing medical treatment goes too far. So I liked that. That's a very nice encapsulation because going too far is what the government isn't allowed to do under Section 1. So it's a very strong, accessible way to make your point. I asked you some questions on things that didn't come necessarily right out of your factum, not necessarily out of Section 1. I asked you about the breadth of the medical exemption. I asked you about your remedy and how that tied in, and you were very well prepared there. And so that, again, is a very high level skill because you don't know what's going to interest the person that is hearing your argument, and you were very prepared to deal with it. Sometimes maybe not even in the right order or in the perfect spot, but you answered the question and you answered it in a way that helped you out. One of the things that's really nice about Section 1, and you can never, I believe, overdo setting out a framework and making sure that that your listener knows, I'm now talking about pressing and substantial objective. I'm now talking about, or this whole analysis fits under, this proportionality, or I'm talking about rational connection now. And using those words to make sure that somebody is situated when you're dealing with, let's say, a card requirement, and to make sure that you're linking back to your legal test. You can't do that often enough in my book to make sure that we're fully understanding what it is you're saying. But very well done. Thank you. And I'll turn to Justice Morgan, please.
Okay, well, Justices Martin and Sossin are hard acts for me to follow now. They've covered the terrain really well. I will say something that Justice Martin just said really twigged for me. A lot of the questions were not from your factums. I mean, we have your factums and we get to study them as much as we want beforehand. But the factums were incredibly smoothly polished. Oftentimes you get a lot of good, grist for the mill right in the factum, and there's all kinds of critiques you can make and say, hey, but you contradicted yourself here. What you say at paragraph 23 isn't exactly what you say at paragraph 43, et cetera. Your factums were, I have to say, right up there with the best factums I would typically see in court. They were excellent. So what that means is that we really had to concentrate on your oral presentation in order to get some good critique or some good commentary here. Ms. Eng, you had, while it's true that Section 1 gives you a nice framework, and so in some sense it's an easier task to argue your way through Section 1 because it gives, you don't have to make up the roadmap. It's already there, it's preset. But you didn't do it in a way that was, sometimes Section 1 arguments come out as almost too formulaic. Yours was interesting. It held my interest right from the beginning. And I commend you on that because Section 1 is nicely set up for you, but sometimes it's almost too rigid. But it didn't have that sense with your presentation. You did start off saying Section 1's never used to uphold Section 7 violations. I think that's true. I don't know if there really, I haven't heard of a case. I'm not sure that there is a case where Section 1 has actually upheld a Section 7 violation. There may be one sporadic one here or there. It does raise the question though, why not? And particularly, I'll just say as a psychological point, almost a personal psychological point, judges love a first. You might be right about that, but you're almost inviting us to get, we all want to get our names into the law school case books in the next edition. But anyway, it is true. judges love a first, but on the other hand, it takes a little bit of gumption to be a first. You might also set a judge back on their heels that way and make them think 3 times before going against you. You also had a hard argument. I thought, I think I wrote down this line because I liked it. You said in a perfect world, vaccinations would be voluntary. I think that's crucial to your point. You said it with self-confidence. It is a potentially controversial statement, obviously. There may be many people out there who think that some might say, that is, there may be many people out there that would say, in a perfect world, there will be no one who objects to vaccinations. That is, we won't have to worry about whether it's voluntary or not. But like I said, you said it with the kind of confidence that didn't prompt me to want to take on the argument. I saw it, I liked it, I saw exactly how it fit into your point. It was kind of a bit of a colorful thing to say, not a sort of strictly doctrinal legal thing to say, but it worked, and I liked it. And then after some tough questioning, I thought you summed up rather well. It's not easy to come back from a series of questions like that and give your conclusion in a coherent way, but you pulled that off nicely. So job well done.
Thank you very much.
Thank you. Justice Morgan, can I ask you to please continue then and deal with Ms. Angelova?
Sure. Okay, Ms. Angelova. The Crown, I think, well, I'm not sure if I would say the Crown has a harder argument than the challengers or not. The Crown often has a harder argument. People often instinctively, especially in moots, cheer for the challenger. So sometimes the Crown feels like it has a harder argument. I think I agree though with Justice Sossin that in this particular instance, there's a lot of people who are kind of craving vaccinations and wouldn't be cheering for the challenger, but that's a matter of taste, an individual viewpoint. I thought your introduction was very nicely written. It was really well crafted, a nice introduction. I'll just say this, it was obviously pre-written, as most introductory sentences are. Sometimes it's good just to mix it up a little bit and improvise, only because you come off, it just comes off more naturally. But this was really well enough written. It was really nicely said. You had this interesting. I commented that it was an interesting point about judicial notice, that we could take judicial notice that people who believe like the challenger here believes will be a demographic that congregates together. Not so sure I agree with that at all, but I was definitely impressed with the kind of the spunkiness that you said it with. It was actually a good moment, you know. I was going to say people who are anti-vaccination might also be resistant to social distancing. They may be, in other words, they may not be ideologically committed to health like this individual is. They may just be libertarians and may be ideologically not committed to government, no matter what government's doing. So it is a tough argument, but that's just an example of the fact that you sort of went off script there to say it and engage me back and forth, but you did it really effectively. So one should never worry. All 4 of you speak very well. You're incredibly well prepared. I understand the instinct to stay on script, but you don't need it because you guys know your stuff. And when you go slightly off script, actually you get heated up and it's even better. Ms. Angelova, you gave me you gave me a bit of a grin back, acknowledging my skepticism, but you kept on going. And that's hard to do. It's hard to be self-confident about your response without being kind of brash or arrogant about it. And I think you pulled that off really well. I'll turn that over. Who's next?
Justice Sossin, please.
Okay, Justice Sossin.
Well, I thought those comments covered a lot of ground, and I'd say I alluded to this earlier, that the challenger has a particular kind of hill to climb in this moment, but so does government, and the hill for government, in my view, is just the huge frustration with what can appear as arbitrary bright lines and distinctions that don't necessarily seem to accord with what this or that expert has to say about responding to the pandemic. And it's, of course, moving in real time. So, I think the Crown had some work to do to talk about those bright lines in a way that conveyed this isn't over breadth, but this is, rooted in an emergency and rooted in a concern for the health of others. And that idea of moving off the humanity of Mr. Yuno to the humanity of others in society who are vulnerable and are going to be put at risk is really the Crown's sweet spot. And I thought you brought that out, especially in the answers to the questions very effectively. And in particular, I like when I think I put a question to you about those, bright lines, and you weren't shying away from what the Crown, what the government had done in crafting this, and similarly the need for some of the measures involved in not being grossly disproportionate to what was required. I thought that was helpful in standing your ground, but in a way that never felt defensive and never felt, overreaching, apart maybe from the neighborhood point that Justice Morgan raised. But it was all very, very effective. And again, even when you were holding your ground, it felt like you were engaging and really responding to the questions, which of course is absolute, absolute the secret sauce of good advocacy. And I never felt like you were just trying to think of an answer that we wanted to hear. I think it was, what's the Crown's position and in the public interest in the framing. And that was, as I said, very effective.
Let me just add to that. Where I thought you really excelled was when you were making the point about what that the goal was herd immunity as soon as possible. All right, and you stuck to that, and you wove in so much to that, and you took your objective and why it was different. And I thought that was very persuasive. You had a good answer on section 12 and about the policy making role and the choice. And I thought that was really, really effective. Your opening was great, and I was with you until you started to talk and you put livelihood above lives. Note your first paragraph, okay? You speak about the livelihood, and then you say, and of course, the importance of lives. But in that small segment there, I'm thinking, but lives are more important, right? I'm almost not following you, because I'm thinking, is the government really telling me that the economics is their focus here? So of course what you said is correct, but watch for your order, because you don't want to upset somebody and take them off the point. And you got to it last, and ask yourself, was it more effective last? Or would it have been more effective to say, of course, this is an agreed upon? And then, but the government has multiple objectives because it must meet multiple goals for multiple constituents, right? So it's just a different way of saying that. I liked the way that there was a great structure in your argument, all right? They did not meet their burden. Really good, because you're telling us it's their burden, and then you're justifying what they failed to do for 3 reasons. Sometimes, though, I wasn't exactly sure which reason I was in. And if you're doing that, and you did it later, you did it twice. You said, this is, I have 3 reasons about this, and you gave them. And maybe when you're doing an enumerated list, it will become easier for your listener to follow you if you say, I have 3 reasons. They're the following: brief, 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 right? And then you tag back to them, you know, and my first reason, and you just signpost along the way. But you did an excellent job when you were talking about, well, you have to look at the government objective, and we look at legislative purpose and context and other exchanges. You have really solid structure. Sometimes, you know, just, I think it would be just a little bit more beneficial to give the structure in its totality, but briefly, and then tag back to it. I liked your bit about bright line rules. I loved your answer about that's too high a cost. Okay, I'm not sure that you planned exactly to say that, but that kind of was a home run answer, and so feel free to make those. I'm going to stop there, Ms. Angelova.
Thank you, Justices. That was very, very thoughtful and helpful.
Thank you. Good. All right, Ms. Awwad, if I'm going to start with you, you started out with safety regulations and a proactive bright line to a behavioral standard, and that was really strong. All right, very strong. And you talked about the different issues under Section 7 and weighing them. You brought up Bedford, and I thought you did a very good job of answering questions that were complicated, because you did not get easy questions. And I hate to say it, but we had warmed up completely to our job by the time that the fourth mooter stood up, and so you were taken and torn from your script a little bit more, but you had a wonderful way of answering a question and using it as what I said, that bridge to what you wanted to say. You said, I'll make 2 points in response. And guess what you did? You made 2 points in response. And that was really good, because I knew, okay, I have to listen to 2 things here. And they were good points. And they were probably points you were going to make in your script, but you pull them from your script because the time has come to make this point in its absolutely most effective way. I pulled you off on the medical exemption part. And then when Justice Morgan posed a question in a bit of a cheeky fashion about judges and, you know, are you saying you don't trust courts kind of thing as a government? And you answered that very graciously, very, very graciously. And well, you brought up the individual and the collective. And in terms of Justice Sossin's question, when he was talking about the individual and the collective and was talking about this being abstract, you did a really good job there, because you started back and you said, this is anything but abstract. Okay, so that is a very effective way of not accepting the characterization that has been put on your argument by a questioner, all right? And that's very brave too, to say that, but it's completely necessary, right? To say that, no, you're using a word that I'm not accepting in that way. And you brought it back and grounded it back in your analysis. And I thought your closing was very effective. And so now I'm going to ask Justice Morgan and then Justice Sossin to give you some further comments.
Okay. Yeah, I'm also going to start off complimenting you. I also liked the prelude about safety regulations. One reason I liked it was because it was a smart thing to do, because it was new. But again, by the time you get to the fourth speaker, we know all these arguments already. We've heard everything there is to hear, and it was a good idea to start with a new angle. And then you did it with a slight, I think this was instinctive on your part. I don't know how much you had to think this through, but with a slight reference to Justice Sossin's previous point, which made it look not pre-canned. It integrated it perfectly into your argument. So that was a nice touch. I really liked, you said after Bedford, we have to take Section 1 much more seriously in a Section 7 case. I think that's a great point. I think Bedford, the heavy emphasis, the heavily individualized analysis that Bedford puts on Section 7 does open up the possibilities for Section 1 in a way that people hadn't thought of before. I think before Bedford, people really did say that did think that there was just too much overlap between those two sections and that Section 1 was really an afterthought. So I think you actually made an important constitutional law point there that we should all take more seriously. I very much like that. I like your explanation about how it's not appropriate it wouldn't be appropriate for the legislation to go beyond medical exemptions. I think you said that would put government and possibly courts in the position of basically of assessing the bona fides and the seriousness of an objector's grounds. That would be incredibly difficult. These are subjective views. And much as judges like to have decisions thrown at them, deference to their decisions, that's not the kind of thing that judges are comfortable with. So I think that was a very cogent point, and I was glad you made it. And then also, I'll just reiterate, I liked also your response to my cheeky question. But judges do get up in a huff sometimes when they think that people, government's trying to take away authority from them because they don't trust them. I've heard that with respect to minimum sentencing. But you responded with enough of a sly sort of smile that you knew that I was being cheeky, but came back strongly anyway. It was a good comeback. And so all in all, I enjoyed your presentation a lot.
So let me finish the roundtable of thoughts by saying this. I agree with those substantive points, and I kind of won't go over the same ground, although I think you had a tough task in moving us off, having been persuaded that there are these alternatives that could achieve much of the goal without the seriousness of the impact. And again, I think you stood your ground and did that. But you also, from a stylistic point of view, had one extra tool in your toolbox, which is one of the rarest tools for lawyers to be able to develop, and one of the most effective when it's used well, as you used it well, and that's silence. And you were particularly effective when you would finish a point before you started a point, of really taking a deliberative pause. And what it meant is, even though you were under lots of time pressures, and we knew we were seeing the same reminders of 5 minutes, 2 minutes that you were seeing, but because of those pauses, it also conveyed that you were in kind of complete command of your arguments, and you were thinking about questions and being thoughtful about how to then continue with your argument. And silence can convey, of course, a lot of things. It can convey deer in the headlights, nerves, and can convey, I don't know what to say next. But when it's used as you used it, it really conveys a sense of deliberative and thoughtfulness, and again, deliberative pauses can be very, very effective. So from a style point of view, each of you had your own style and used it to great effect. But I was particularly impressed with the use of the silence in making what was a short period of time feel like you were relaxed, not rushed. And that, of course, conveys confidence and ultimately assists in how persuasive your arguments come across. So with that, let me turn it back to our fearless Chief Justice for any final thoughts. And again, it was such a pleasure to see all the hard work, effort, passion, toil, sweat, all those great words in service of something that we know is not like a law school exam. It really has to be a real commitment of your own sense of the importance of advocacy, and it came across and was a real pleasure.
Well, thank you. Do any of the mooters have specific questions for the panel at this point?
I I have one very brief question, just because we were talking about judicial discretion, and I was thinking about both of my submissions on penalty, and I know there are a lot of gross disproportionality cases about minimum sentences, but I've never seen one about a maximum, which is what I did here. And so I was curious how the court took that and whether you think that would fly in an actual court, or the kinds of things you'd have to think about in making that argument. And I'm referring to the jail, the 14-day sentence, which is at the top end of the range, because it seems like judicial discretion can kind of come back to bite me on that argument.
Who would like to respond? Anyone like to respond to that first?
Yeah, I'll just say, I hadn't thought of it that way as the way you put it. It's a good question. I mean, it's akin to arguments about cruel and unusual punishment, which don't have to be torturous punishment. They just have to be out of proportion to the offense. Something that's a normal punishment in for one offense might be cruel and unusual for a petty offense, that sort of thing. So I think that's where you would find similar type arguments. But you're right, I haven't really heard judges logically, there's no reason why not, but typically the judicial affront at having their discretion removed in sentencing is with minimums, because they think that governments don't see the frailties of the individual that's before them.
Well, I think though, Justice Morgan, here the other challenge, which we didn't get into as much in the questions, but I know is in the factums, is there really isn't a maximum, because there can be this recurring sentencing indefinitely. So in effect, it's depending on how you characterize it from an advocacy point of view, it's either a maximum of 14 days or simply a procedural requirement to keep renewing that to result in effectively indefinite imprisonment.
Yeah, it's somewhat similar to contempt of court, which also you can just keep renewing as long as the person doesn't purge the contempt. So it's not an unheard of penalty, but it does, you're right, it's egregious after a while. But it would be interesting to see judges kind of getting a all defensive about their discretion being taken away at the top end in the way that they do at the bottom end.
Well, and I think we're used to top end. If you look at the criminal code, mostly the penalties are stated as maximums, right? And so I think that that's just an oft-used technique. I mean, what made me smile about the problem was that it was 14 days, which is become 14 days has become, the quarantine and the this and the that. But the point that I would make to you, Ms. Pasca, about that is that I didn't understand you were making that point until you asked me that question. All right. And so that's interesting too, because so I didn't hear that the same way maybe that you said it or whatever. And if it's going to be something that you're noting as a crucial plank in your argument, and that it is something that is a bit out of the ordinary, it's not a bad idea to flag it and to be very upfront and express about it, because especially when you have an answer that would meet any of the concerns raised. So that's what I would say about that.
Thank you, that's very helpful.
Anybody else have a question? Okay, well then it is my turn now to kind of close our end of the proceedings. And I'd just like to say that a great congratulations to the mooters for your presentations. Mooting requires diligence and an incredible amount of discipline. And you've achieved a standard of excellence for law students that is very, very impressive. And that does not come without a lot of hard work and the participation of many people helping you through practice rounds and reading things. And so it is kind of a nice collective effort. And I'm sure that Justices Sossin and Morgan will join me to say that thank you for inviting us to this event and to be able to preside. It is a joy and a delight to see people so dedicated in active education. And we understand just how difficult it is in these last couple of, in the last year or so, to be fully engaged in your education, but nothing is more important. And it was just so heartening to see what great strides are being made with technology and bright, dedicated people who are going to help make this a great profession. So thank you. And that brings our formal part of this to an end.
I'd like to extend our sincere thanks to the justices for your kind words and for taking the time to join us today for our first ever virtual Grand Moot. We want to take a brief moment before we conclude to recognize the contributions of everyone who assisted with making tonight's moot possible.
We'd like to thank all of the faculty members and practitioners who volunteered their time to help us with drafting the Grand Moot problem and judging practice run-throughs. You can find their names in the virtual program circulated at the start of the moot. We would also like to thank the bench clerks and other moot court committee members for all of their assistance with making this event possible. Their names are also included on the program. Of course, we would like to again thank our distinguished panel for contributing their time and their valuable feedback. We would not be able to run this event without you, and we truly appreciate your commitment to the mooting program. And finally, we would like to express our gratitude to McCarthy-Tétrault for their longstanding support of the Grand Moot. Their generous contribution of their resources, time, and expertise continue to make this fantastic evening of mooting a possibility. And with that, we would like to invite Bill Black to say a few words on behalf of McCarthy-Tétrault.
Good evening, justices, faculty, honored guests, students, and mooters, Grand Mooters. I have been lucky enough to attend a number of these Grand Moots over the years, and it is an event that never fails to conjure up for me a similar set of feelings. I remember the very first Grand Moot I attended back when I was a student in the mid to late 80s, not as a mooter, I assure you, but as a classmate of mooters. And I remember thinking how very brave those mooters were and how very able. And tonight, again, I am struck by those same sorts of thoughts. In terms of bravery, I guess a lot of the audience tonight is comprised of litigators, so I suspect I'm preaching to the converted. But to be sure, it takes a certain amount of courage and resolve to stand up before a panel of esteemed judges like these, and before a large collection of classmates, friends, and family, and to be prepared to make forceful arguments and to test your intellectual mettle. It can be nerve-wracking for a seasoned litigation lawyer. We all, or most of us, or certainly I, still feel adrenaline and butterflies when we stand up to address the court. And for students in law school doing this for the first time or among the first times, I can only imagine that those butterflies must be the size of beagles. But having watched the mooters perform tonight, you would not know that they experienced even a moment of trepidation or anxiety. They each, and this now is also part of the reaction that I have tonight, as I invariably have each time I attend this event, they each acquitted themselves with ability and aplomb beyond their years. And frankly, as I suspect the panel can attest, beyond the reach and level of many of us who do this for a living. You were all smooth, but powerful and very effective. And that is evidence of a great deal of hard work and preparation, as well as evidence of your innate talent. And that observation leads to the next feeling that this event inevitably sparks in me, which is that the future of our profession, and of the litigation bar in particular, is going to be in some very good hands. And I suggest that that is actually very important. And I think we've all had to focus, having regard to events south of the border in the last 4 years, and especially in the last 4 weeks or so, on important facets of our democracy. And I believe that the ability for people in our society to deal with their disputes through the courts, by putting our differences in the hands of judges who are in that role specifically because we trust their judgment, contrary to one of the questions that Justice Morgan asked a mooter tonight, but specifically because we do trust their judgment, And that is a critical part of allowing our civil society to function. And the role of the advocate in that system is paramount. And again, having seen you mooters in action, I think we can all feel confident that the system will be well served going forward. And so, as is invariably the case with this event, I feel encouraged and buoyed up by seeing such excellence on display at such an early stage of your respective careers. It really is a great privilege, and here we come to the branding moment. It's a great privilege for McCarthy Tetro to host this event every year, and this year is no exception. Mooters, you have done us proud. I also wanted to note the role and the effort of the student organizers of this event. This year, and I'm not sure why, I was lucky enough to receive a copy of the materials that the judges received, including in particular the bench memorandum prepared by Saambavi Mano and Alina Yu of the Moot Court Committee. And I have to say how impressed I was with the effort and the quality of work that went into that bench memo, and indeed that went into the moot as a whole. You two and your colleagues are to be congratulated for your hard work and your incredible accomplishment pulling all of this together. I was also struck, and this brings me to the second part of my remarks, I was also struck by how easy the judge's job really is. That is, the bench memo had detailed analyses of all of the issues, and it even had a list of many potential questions for the judges to consider asking. I can remember in the past being impressed at how seamlessly the Grand Moot justices have been able to master the issues and generate insightful and probing questions. Now I understand how they do it. So when I said I was coming to the second part of my remarks, when I've given this address in the past, I've taken the opportunity to poke gentle fun at the bench. I figure it's an occasion of privilege and people are in good spirits, and so what better time to get away with irreverent comments about the bench? Also, the organizers have made the grave tactical error of giving counsel the opportunity to speak after the judges, not an opportunity typically available. And when I've done this in the past, golden opportunities have presented themselves. The last panel, for example, that I had a go at included Justice Moldaver, now of the Supreme Court. But back in the mid to late 80s, when I was in law school, Justice Moldaver, who was then a criminal practitioner, taught a course together with his friend and colleague Casey Hill, who was a Crown and later went on to be a judge. And essentially, the two of them argued and poked fun at one another about cases that they had on the go. We students called the course Criminal Anecdotes, and it was one of my favorite courses. It also yielded a great deal of material from which to poke fun at Justice Moldaver. He taught that course before he had developed any judicial filter, and as I suspect Justice Martin can attest, even now his judicial filter is not all that effective. So there was lots of material. Also on that same panel was Justice Sharp, then of the Court of Appeal, but back during my time at law school, someone who taught me Civ Pro. Now, hard to find any material really to poke fun at Justice Sharp because he was so reasonable, in fact, to the extent that we students called him Reasonable Bob. But I told him that during the course of my remarks, and I think it was news to him. In any event, I had material that time. And in particular, I could remind the panel of the way we students had perceived them when they were professors. Unfortunately, this year, I had a dearth of material in 2 of 3 cases and an inability to use the material that I have in the 3rd case. Let me explain. Starting with Justice Morton, of course, I took no classes from her. She did teach law school, but all-knowing Wikipedia tells me that it was at the University of Calgary. Now, I am from Edmonton, and therefore the fact that she spent time in Calgary would normally be fertile ground for gentle or not so gentle mockery. But it strikes me that this is an inappropriate forum and occasion to air intra-provincial grievances. Moreover, I cannot help but admire her judicial accomplishments. The Carter decision, for example, shows her to be a wise and compassionate jurist. So really nothing to work with here. Turning to Justice Sossin, again, no joy. There is, of course, the Osgood thing, but again, this seems like the wrong forum for a debate about rankings between Toronto versus Downsview-based law schools. And of course, I say confidently to the largely University of Toronto audience, there really can be no debate. But in any event, I thought I'd best leave that alone too. And Justice Sossin has exhibited such a remarkable and meteoric career path and now sits in the Court of Appeal, so why take a potentially career-limiting chance? And that then brings me to Justice Morgan. Here I have material. In fact, I have a couple of rich sources of material. He won't remember this, but back in that period in the mid to late 80s when I was at law school, he taught me real estate law, I believe, in third year. Now, I imagine there are people who find real estate law fascinating and exciting. I am not one of them, and I'd be prepared to wager neither is Justice Morgan. Moreover, in addition, I have spent considerably more time with Justice Morgan in the last couple of years than I have spent with most members of my family. I have had a 14-week trial before him in 2 phases, such that I am certain that hearing my voice yet again tonight must ring to him like fingernails on a chalkboard. But I have material. The problem is that his decision in the second phase of our trial remains outstanding. And a tip for you young advocates, never make even gentle fun of a judge who has one of your cases under reserve. Also, if pressed, I will admit at the risk of seeming sycophantic, that Justice Morgan presided over a very difficult case, that 14-week trial I'm talking about, with very difficult facts. And he did so with patience, compassion, and dedication, and even at times, when permitted, with humor. And lest there be any doubt about Justice Morgan's sense of humor, I commend to all of you his 2014 decision in a case called Moreland Jones and Terk. In that case, Justice Morgan was dealing with a dispute between wealthy neighbors in the Forest Hill neighborhood in Toronto over a series of silly and trivial grievances that they had with one another. It is one of the funniest pieces of judicial writing you will ever see. It is rich satire in the form of a judgment, and it is actually, I don't know if Justice Morgan knows this, but it has developed a large underground following. So, in the end, not much basis and no incentive whatsoever to launch barbs at Justice Morgan. So I apologize for that. But let me at least end on an up note. Let me again congratulate all concerned for this wonderful event, and to thank you all again on behalf of McCarthy's for allowing us to continue to bask in your glory. And now, to borrow a phrase from Ms. Angelova, I will cede the screen to the student justices. Thank you.
Thank you so much, Mr. Black. And just on behalf of all of my teammates, I just want to extend sincere thanks to everyone who came out to watch this event. It's been quite a challenge and very interesting preparing for it virtually. And it's really rewarding to get to do this in front of our entire community, and not just our fellow students, but everyone watching on YouTube and everyone tuning in that way. I would also like to thank on behalf of everyone, the law school, everyone that supported us from the law school, everyone who helped us with run-throughs, of course, our esteemed judges and McCarthy Tatro, and finally, Alina and Saambavi, who are our rocks, and they worked so hard on this incredible project, and we're incredibly grateful for that. Thank you so much for coming.
Thank you, and thank you all for coming to the Grand Moot. A recording of this event will be on the UT Law YouTube account in the following weeks.